Hello, my name is Aditya Gupta and I am a lawyer practicing at the Delhi High Court. Today I will be dealing with the module of trademark infringement and passing off. By the end of this module, I hope you will understand the different rights which are available in a trademark, both under the statute and under common law, the rules for determining infringement of trademark, and the rules for finding out passing off, as well as the difference between trademark infringement and passing off. Let's begin. First, let's understand the nature of the rights that are available under a trademark. Rights are available to a trademark proprietor both under the statute and under common law. Statutory rights are available only with respect to registered trademarks. The Trademarks Act provides a detailed procedure for the registration of marks, and if a trademark is granted by the trademark registry, then the proprietor of such a registered trademark is entitled to certain rights under the statute. In contrast, even if a trademark is not registered, there are rights which are available under common law. Therefore, a person may not have gotten a registration under the Trademarks Act, but he or she will still be entitled to certain rights under common law. Typically, even registered proprietors of trademarks claim common law rights. That is, they say that while they are entitled to the rights under the Trademarks Act, they are also entitled to common law rights with respect to the goodwill and reputation that they have developed over the years. Section 27 of the Trademarks Act is relevant here. Section 27 says that no suit for infringement of a trademark can be filed with respect to an unregistered trademark, but at the same time it contains a savings clause. It says that the first part of section 27 will not affect the ability of a person to claim passing off of an unregistered trademark. I hope you now understand the correlation between the statutory and common law rights available to a trademark proprietor. If a person is able to obtain a registration for a trademark, he is entitled to two rights under the Act. The one is the right to use the trademark in the course of trade, and the second is the right to obtain relief, that is, the right to stop others from using the trademark in the course of trade. Therefore, for instance, McDonald's, the burger chain, is able to obtain a registration for the trademark McSwirl. The trademark registration gives the McDonald's two rights, that is, the right to use the trademark McSwirl, as well the right to obtain relief against another person who uses the trademark McSwirl for ice creams. Now let's understand the test for infringement of a trademark. There are four situations possible here. A defendant or an infringer may be using an identical mark for identical goods or services. For example, someone uses Tata for steel. As you know, the Tata Group is the owner of the Tata trademark and it makes steel, and since the infringer is using an identical trademark for identical goods, this amounts to infringement of trademark. The next situation is where someone uses a similar mark for identical goods or services. Again, taking the Tata example, let's say someone uses the trademark Tattva for steel. Here the trademark is similar to the Tata trademark and the goods are identical. Third is where the use is of an identical trademark for similar goods or services. I'll take the Tata example again. Compare Tata for steel versus Tata for cement. Here the goods are different, but they're still similar in nature and the marks are identical. Lastly, where the use of a similar mark is made for similar goods or services. Again, Tata for steel versus Tattva for cement. All of these four situations are captured under the Trademarks Act and are considered infringement of a trademark. Now let's move on to this concept, from whose eyes should likelihood of confusion be judged. Way back in the year 1962, the Supreme Court of India identified such a person from whose eyes the likelihood of confusion needs to be judged. The likelihood of confusion needs to be judged from the eyes of an unwary consumer with average intelligence and imperfect recollection. Now, when I say confusion, you must understand that the bedrock of trademark law is confusion. Trademark law exists to prevent consumer confusion insofar as you do not want consumers to be confused as regards the source of the goods. Therefore, the courts have laid down this test keeping in mind the common man, and they believe that the common man will have average intelligence and imperfect recollection. The common man will not remember the details of each and every mark and will not thus be able to distinguish the marks by keeping them side by side. That's why the test seems to be a low one. The threshold seems to be a low one. The question is, does this test also apply to more expensive goods? For instance, if a person is going to buy a car, is it likely that he will be more discerning regarding the goods that he is buying? Will he not find out more about the car and will ensure that the brand that he is buying is the one that he intends to buy? Courts do consider this factor when determining the likelihood of confusion, and for more expensive goods, there are certain courts which have held that a more discerning standard must be adopted. Now let's move on to the question of how do consumers interact with trademarks. This is important for you to understand the tests which have evolved over the year for determining the similarity between trademarks. Let's go over these one by one. First is, the brand itself is not a memory target. What does this mean? This means that consumers don't necessarily remember the brand immediately, and it is only a cue that facilitates the recall of previously learned brand associations. This means that a person may not remember the brand exactly. It may have certain associations with certain parts of the brand, and this may be a word, a numeral, a trade dress, anything of that nature which is distinctive. Therefore, distinctive brands and packaging are highly conducive to mental associations. The consumers associate a particular distinctive part of a product with a particular brand or a particular source of goods. What happens if someone else starts using a similar mark? It causes a slow decline in the accuracy of consumers' memory-based judgment. This means that consumers start doubting that whether the association that they had with a particular brand is correct or not, whether they can any longer rely on a particular word, numeral or type of packaging to be sure that the product comes from a particular source. Therefore, Trademarks Act seeks to put a check on such practices to ensure that there is no decline in the accuracy of consumer-based memory judgment. This means that there should be no consumer confusion. Now that you know the rules of how consumers interact with trademarks, let's see the rules for determining the similarity of trademarks. It is now well settled that the side-by-side comparison of trademarks is inappropriate. What the courts have realized is that consumers usually do not have the proprietors and the infringers' trademarks side by side for comparison. Usually, the consumer is relying on some old memory association that it has with a brand, and therefore, it is in that light that courts must also judge the similarity of trademarks. Therefore, it is important that the courts must not look at each of these goods and try and find out differences between the plaintiffs and the defendants' products or trademarks. It is important for the court to only look at the distinctive part of the trademark, understand what the consumer is likely to have remembered, and then consider whether a consumer will get confused or not. To understand what are the kinds of similarities that can be seen, the courts have held that the visual and phonetic similarity between the marks must be seen. That is, whether visually the two trademarks are similar or they sound the same. Over the years, the courts have also developed a test for similarity of ideas between two marks. This means that even though a trademark may not be visually or phonetically similar to a previously registered trademark, it might have the same idea. Let me give you an example. For instance, if a brand of malt chocolate powder has a sporting logo on its packaging, that is, it shows people playing football on its packaging. Now another person comes and introduces another malt chocolate powder and shows a similar logo wherein the dress of the football players is different and the way they are represented is different, but the idea that people are playing football is copied. The courts have said that in such a case, it is quite likely that consumers will only remember the fact that there is a logo consisting of people playing football. Consumers may not really remember the color of the football players or their position on the football field, etc. Therefore, even if the idea of a trademark is captured and is copied by a defendant, it may be considered trademark infringement. Now, the courts have also evolved the rule of anti-dissection of trademarks. First, to understand the concept of anti-dissection, you need to understand the concept of composite marks. Quite often, you would find marks that are composite in nature, that is, they have some distinctive part and some non-distinctive parts. When I say distinctive, distinctive means distinctive to the trademark owner, that is, it immediately leads the consumer to associate a particular mark with a particular source of goods. When I say non-distinctive part of a trademark, it means those parts which belong to the world. For instance, if I say Tata Steel as a trademark, Tata is the distinctive part of the trademark, steel is the non-distinctive part of the trademark, because steel is a generic word which anyone is allowed to use. When you consider such composite marks, courts have also evolved the principle of anti-dissection. The principle of anti-dissection means that while considering a composite mark, courts cannot break down these marks into the distinctive part and the non-distinctive part. In fact, the courts have said that the mark must be considered as a whole, and the effect of the mark on the consumer must be considered as a whole when the marks of the plaintiff and the defendant are being compared. Also, with respect to composite marks, the copying of the distinctive features of the mark is relevant. That is, it is also required to be seen whether what the defendant has taken is the essential or the distinctive feature of the mark. A defendant, of course, is allowed to use the non-distinctive feature. But again, it is important to note that the overall effect of the mark has to be taken into account. Another very important aspect of trademark infringement is that no amount of added matter is relevant. This means that even if the defendant has added a prefix or a suffix showing that it is different from the plaintiff, the court will still say that this added matter is insufficient to dispel consumer confusion, and thus it still amounts to infringement of a trademark. Please do remember that this rule of added matter is only applicable to infringement of a trademark and not to passing off. We will deal with this aspect in detail later. Now let's move on to certain examples. The examples of a marks which have been held to be similar include Glucovita and Gluvita. You will see that these marks, Glucovita and Gluvita, are both phonetically and visually similar. Similarly, the mark Rasmola and Hajmola have been held to be similar. Here, this visual similarity and the phonetic similarity is not very apparent, but considering the class of consumers who would consume such products, it is quite likely that they would remember the term mola, and that is the descriptive part of the trademark which they might remember, which might cause consumer confusion. Another interesting case is one of collector's choice and officer's choice. In this case, the plaintiff did not have rights over the mark's choice. It was the proprietor of the trademark's officer's choice. If you look at it, officer and collector are not visually or phonetically similar. However, in this case, the Delhi High Court said that there was a similarity in the idea of an officer and a collector, and a collector in fact was a type of an officer. Thus, based on the concept of similarity of idea of a trademark, the court held that the mark officer's choice and collector's choice are similar to each other. Let's now move on to examples of trademarks which have held not to be similar. First is Prima Sport and Prima Mark. Here in this case, the court said that the plaintiff did not have the right over the trademark Prime, and otherwise the Primark and Prime Sport sound and look very different. Another example is Piquant and Picot, and another one is Timo Get and Timo Chem. One might wonder why the marks Timo Get and Timo Chem were held to be dissimilar. It is important to note that both these trademarks were used for pharmaceuticals and were derived from the active pharmaceutical substance which is used with respect to the pharmaceutical. Therefore, since Timo related to the active pharmaceutical substance, it could not be distinctive of the plaintiff and could have been used by the defendant as well. And the remaining part, Chem and Get, were clearly dissimilar. Therefore, even though the anti-dissection rule applies, it is important to note that the defendant is always allowed to copy the non-distinctive features of a trademark. Now let's take into account certain other relevant considerations. What if the class of consumers of the plaintiff and the defendant are different? Quite often, defendants try to raise a defense that the pricing of their goods is very different from the plaintiff's goods. Let's say, for instance, in the case of a car, I might say that as a defendant I might say that the cost of my car is only 1 lakh rupees while the cost of the plaintiff's car is 10 lakh rupees, and because of this there is no likelihood of confusion. While some courts do give weightage to this fact, slowly and steadily this factor is becoming less and less relevant. Courts are saying that since cars may be sold online, people may be still diverted to the less expensive car when they are looking for the more expensive car. This confusion is sufficient to cause trademark infringement. Let me give you an example. If two car manufacturers are using very similar trademarks, let's say Tata and Tatva, while searching for Tata, even if I come across the Tatva car, I might go and visit the Tatva website. I may not buy the Tatva car which is only worth 1 lakh rupees, but because I have gone and visited the Tatva website, I might look at its other cars which might lead to trademark infringement. This is called initial interest confusion, because even though at the time when the consumer will buy the Tatva car, he or she will know that it is not a Tata car, but because the consumer has visited the Tatva website, because of its confusion with the Tata website, it will be considered trademark infringement. Also, another important consideration is that in a trademark infringement case, actual confusion need not be proven. That is, a plaintiff need not show that actually a consumer was confused because of the defendant's use of the trademark. All that the plaintiff needs to show is that there is a likelihood of confusion, and that too from an eyes of an unwary purchaser with average intelligence and imperfect recollection. Now, it's also important for you to know the kinds of uses that can be considered as infringement. 1. The use of a trademark as a trade name or a part of a trade name. Therefore, if a defendant goes to the registrar of companies and registers a corporate name which is similar to the plaintiff's trademark, then the plaintiff can file a suit for infringement of the trademark before a court. Second, the affixation of a trademark to the goods or packaging. Therefore, if the defendant uses an identical or similar trademark on its goods or packaging, then it is liable for trademark infringement. If someone puts the goods on sale on the market, that is also considered trademark infringement. Fourthly, the import or export of goods which misuse another person's trademark is considered trademark infringement. Lastly, use of the trademark on business papers or in advertisement is also considered trademark infringement. Therefore, you might notice that the Trademarks Act seeks to impose liability on many different actors. Even though all of these acts may be performed by one person, it is important to impose liability with respect to each of these acts so as to avoid a situation where a person goes scot-free for trademark infringement because it is not performing one of these acts. Now, let's move on to the second part of the rights which are granted in a trademark, that is the common law rights. As I mentioned earlier, there are two types, the statutory rights and the common law rights. When the common law rights are infringed, we move to the law of passing off. Passing off has three elements. 1. That the plaintiff must prove that its mark has reputation. Secondly, the plaintiff must prove that the defendant has misrepresented. When I say misrepresented, I mean that the plaintiff must prove that the use of the mark by the defendant is likely to lead to consumer confusion such that people are likely to believe that the defendant's goods originate from the plaintiff. Lastly, the plaintiff must prove that it has suffered some injury or loss. Now let's try and understand what is the difference between passing off and infringement. Passing off does not use the added matter doctrine that I mentioned earlier. In passing off, a defendant can take a defense that because of the surrounding circumstances, because of the prefix, suffix or other trade dress differences between the plaintiff and the defendant's use of a mark, the consumers are not likely to get confused by the defendant's use of an identical or a similar trademark. Secondly, in respect of common law rights, it is important for the plaintiff to prove reputation. Therefore, if a person has to claim common law rights in a trademark, he or she must show a long continuous user of the trademark such that it has acquired a reputation in the mark such that people associate that particular mark with that particular person, and only if such reputation and goodwill in the mark is proved can he or she claim common law rights in the trademark. In contrast, with respect to trademark infringement, it is not at all necessary for the plaintiff to prove reputation in the mark. So long as the plaintiff has acquired a registration before the trademarks registry, he or she can claim trademark infringement irrespective of the use that the plaintiff has made with respect to that trademark. Let me summarize the concepts that we have studied today. We first studied the distinction between the statutory rights and the common law rights in a trademark. The statutory rights are conferred by the Trademarks Act for a registered trademark, and the common law rights arise from common law and are with respect to an unregistered trademark. The Trademark Act specifically provides that a suit for infringement cannot be filed with respect to an unregistered trademark. However, at the same time, it recognizes that the relief of passing off is still available to any person who has common law rights in a trademark. There are two rights which are available to a registered proprietor for trademark, that is the right to use and the right to obtain relief. Then we also studied the concept of an unwary consumer with average intelligence and imperfect recollection. This is the person from whose eyes likelihood of confusion needs to be judged. There is some variation of this principle when the goods in consideration are more expensive. In such cases, the consumer is considered to be a discerning one. Then we studied as to how consumers interact with trademarks. We also understood how the distinctive part of the mark is the most relevant in forming a mental association, and thus the Trademarks Act seeks to protect this distinctive part of the trademark and the decline in the accuracy of a consumer's memory-based judgment. We next studied the rules for determining the similarity of trademarks. These rules are very important and have evolved by case law over several years. The side-by-side comparison of trademarks is inappropriate. The visual and phonetic similarities of the trademark must be seen. The test is of similarity of ideas has already also been adopted. The rule of anti-dissection has also been adopted in India. An added matter is not relevant with respect to trademark infringement. We also looked at the concepts of different in class of consumer owing to difference in prices and its decreasing relevance, and we studied that actual confusion need not be proven in a trademark infringement case. We also studied the law of passing off, its three elements, and the difference between trademark infringement and passing off. Thank you.